Good afternoon. Thank you for joining us for Restructuring, Insolvency, and Troubled Companies 2024. This is episode number 1, Help, My Business is in Trouble. My name's Thad Wilson, and I'm your moderator this afternoon. This webinar is part of the Financial Poise webinar series, Restructuring, Insolvency, and Troubled Companies 2024. Slide 7 provides a summary of the series, and Slide 6 summarizes this episode. Speaking of the slides, you should understand from the get-go that we will not step through the slides in order, nor will you have to listen to us read from any of the slides. This webinar, like all Financial Poise webinars, is a conversation. But keep the PowerPoint handy because I will try to indicate what slides our conversation is touching on as we proceed so you can take notes. The conversation we're about to have is meant for general educational purposes only, and does not replace the need to consult with an attorney, accountant, or other appropriate professional. Our esteemed panelists today are Candace Klein, a partner at Saul Ewing in Chicago, Steve Golden, a partner at Pacholsky Stang, Zeal & Jones in Delaware, Jonathan Friedland, a partner at Much Shellist, and again, I'm Thad Wilson, and I'm a partner in the Bankruptcy and Insolvency Litigation Group at King & Spalding in Atlanta. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us, but you can read a little bit more about us on slides 39 through 43. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. And if you're attending the live premiere of this webinar, you can submit questions using our web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer. A special shout out today and thank you to our sponsors, the great folks at Mood, Sunburst Digital, Max Asset, and the Daily DAC. There's some info on these great sponsors in the materials. With that, I want to kick it off. So Candace, businesses and clients often have certain objectives in mind when pursuing any form of a restructuring. What are some of those potential objectives you have seen when you've worked with troubled businesses, and how do the company's constituencies affect the decision-making process when they're in distress? And I would commend people to slides 12 and 13 in the materials.
Great, thank you, Thad. Companies have various objectives when they're looking at a restructuring. One obvious one, certainly covered in the press, is to lower costs. They may want to change or pivot focus, change markets, product mix, reposition, prepare for sale of the company, or even, for example, some strategic M&A. Around this process is often some lender compliance issues, right? So relationships with secured creditors. There may even be a loan default. So, anything that's being done now is often to improve compliance with senior creditors. The companies may also be dealing with litigation. It may be, threaten the company type litigation. This could involve customers, suppliers, landlords, if that's important to your business, think WeWork, or even the government, right? So there's a lot of threats that businesses must cope with. And one way in which they address these threats is through a restructuring process. I'll just also note, in addition to those slides mentioned by Thad, that slide 15 lists a variety of these constituencies that companies must consider and work with when they're going through a restructuring process.
Thad, you're on mute. I'm sure it's a great question you're asking about.
Yeah, thanks, Candace. And Steve, I want to turn it over to you.
Hey, I want to before that, I want to overlay.
Yeah, sure. Go ahead, John. I'm
very pushy. So the one thing Candace didn't mention was, if you're looking at the generic question, what are the objectives, right? Restructure is one big bucket. Shutting it down and walking away is the other big bucket. And sometimes that's exactly and the only thing that the owners of the company want to achieve.
And well, so to follow up on that, John, in what circumstances do you see companies just wanting to, throw their hands up and shut it down?
Well, it could be a variety of circumstances. You may have a business that has really outlived its usefulness, and let's say the owners are older and they don't have anyone in the family that wants to take over the business, or anyone else that wants to take over the business. And perhaps there's been a number of years with sort of diminishing income revenue year after year, to the point where continuing to operate doesn't make a lot of sense. And they just want to, wind it down and make sure that they pay their creditors either in full or as much as they can, minimize or eliminate any personal liability, and walk away and retire to Florida or Portugal or wherever they may want to retire to. That would be an example.
Steve, Candace, any other thoughts on why companies may just want to throw up their hands, or owners of businesses might want to throw up their hands and be done?
Yeah, I mean, think of businesses as basically projects. They're not intended really to live forever, and few do. So, once it's lived its useful life, right? So what Jonathan was talking about is, hey, the owners, they want to move on, they want to retire, they want to try to get what they can through the sale of the business or the sale of the assets and just do something else. And sometimes that is the answer. Oh, we just want to do something else. All of those considerations are important, but it is often mandated by a lender. So that, the retirement option is if you have run a good business and you can satisfy your debt obligations. If you cannot satisfy your debt obligations, then your lender might answer that question for you.
What about mass torts, right? Like, let's say you've got a business that's facing some existential kind of mass tort related issues, asbestos, some type of products liability. What do you see in those circumstances in today's market? Are people trying to reorganize, or is it something totally different?
Yeah, it's a mix. I would say it depends on the health of the balance sheet and the strategic considerations of the company. So companies that have faced mass tort liability but have healthy balance sheets, what they'll do is try to hive off that liability. I'm thinking, for example, Owens, Illinois recently hived off an asbestos subsidiary. The asbestos subsidiary files bankruptcy, right? And the bankruptcy code has a section 524G, to deal with asbestos cases. Now, everyone else facing mass tort liability, if you're not just settling, and there's all kinds of ways to get to settlement, ask Walmart, ask Cardinal Health, then you might be looking at trying to use the bankruptcy process offensively, even if it's not asbestos oriented. The Supreme Court recently held in a case called Harrington versus Purdue Pharma that there are limitations to that strategy. So, whether it's non-asbestos liability or whether there's a desire to try to release related non-debtors, such as the very solvent parent of the company seeking to discharge the mass tort liabilities, that's to be continued. So folks are trying to figure out what the parameters are. The Catholic diocese cases are an issue. Boy Scouts, they had that same sort of dynamic. It looks like they're through the process. The Supreme Court tried to limit the effect of their ruling in Purdue Pharma so that it wouldn't go after plans that have been confirmed and gone effective and substantially consummated. But yes, everyone else needs to think about how the Chapter 11 plan works and how you get consent and what does consent mean. And the courts are chewing through those issues now in mass torts.
Yeah. So Steve, that sounds all pretty complicated, right?
Yeah.
So if the directors and officers of a company are perceiving financial distress, whether from mass tort or for other reasons, should they seek to hire experts like lawyers, financial advisors, bankers? And are there things that directors and officers should avoid? And how should they message their financial distress to the market, their customers and vendors and suppliers?
This is probably the easiest possible answer I can give to your first question. The answer is an unequivocal yes. Yes, you should. And this is not to say you have to hire any of us. You have to hire some professionals. Unless you are a restructuring professional, you are probably not very well versed in the dynamics of restructuring and all these different things that can happen, what the bankruptcy code can do, and what Article 9 is, and what an ABC is. This is why there are those experts out there. And look, let me just take the example that Candace just started with, which is the mass tort. If you're an inside general counsel for a company that's facing a bunch of mass tort liability, whatever that mass tort liability may be it asbestos, be it other products liability, whatever it is, you should absolutely be reaching out to counsel very quickly, restructuring counsel, and talking about what can the bankruptcy code do for me? What are my options? What can happen here? What's our how solvent are we now, and how long do we have given this run rate until we start getting into a little bit of a bad situation, given all the professionals we have to pay to defend our these tort liabilities, these tort cases that are out there. So these are really important questions that a business that is kind of looking down the barrel of some sort of financial or other distress needs to deal with. And the best way to deal with it is to bring in people that have seen it before. And here's the thing: we've all seen it before. We've seen it all before, or some variation of it. So definitely talking to those advisors and bringing them in as early as possible is the most important thing. Because look, to your second point, and to your second question about what should you avoid, the thing you should avoid is making things worse. And sometimes, unless you know what it is that will make it worse, you don't know what to do it. And again, I can't tell you how many times we've been, my firm has been, approached and retained by a client that, had they come sometimes even a month before, we could have done more. We could have done something else to help. So when you're in that situation, when you're seeing something on the horizon, reach out to professionals. And the first people I would normally call are a financial advisor and a lawyer. Investment bankers are super important. They're great in the process, but they're usually doing a very specific thing when you're going through a very specific process. So that's the first thing, Thad, and that's the most unequivocal yes I can give. Bring them in early. And look, here's the other thing I'll say about it is that we this year alone, and I know the three of you can probably say about the same thing. I can think of 5 cases or 5 clients I've worked for on company side, debtor side clients that have not filed and will never file for bankruptcy. Just because you bring in a bankruptcy lawyer or a restructuring expert doesn't mean you're filing for bankruptcy, because, as I think we'll discuss, there are a bunch of tools that are out there, and sometimes acting offensively rather than having to go defensively, those options are much more available to you. And as time goes on, you get closer and closer to insolvency. That's when it really kind of tamps down. And to that point, look, if you're a director or you're an officer of a company, you have fiduciary duties. So you should be thinking about those. And look, I'm not going to tell you what your fiduciary duties are because I'm not your lawyer. Also, your fiduciary duties may vary by what state of incorporation you're in. But suffice it to say, you have them. And if you're in a situation where you are in the zone of insolvency or teetering towards the zone of insolvency, your obligations may change. And you should really be thinking of those and making sure you have counsel who can tell you, hey, guys, here's what you have to think about right now. That's super important. And look, you asked a good question, Thad, about messaging. There's a lot of things I can say right now, about what messages you can have. I think you can go into SEC filings and other press releases and read the jargon that is often used. But ultimately, depending on what your situation is, these professionals have done it before. I am not only a lawyer, I'm apparently a spin master, because I've written these press releases before for my clients. We all have to do it. And so getting the people in that can advise your company as soon as possible, literally the most important thing.
Yeah, that's really, really good advice there, Steve. And, one of the things that we see lenders often demanding, right, is the employment of a chief restructuring officer. So, an open question to the group, right? You see a chief restructuring officer being appointed at a company. What should you be telling your customers and your vendors and suppliers in that context? Because next thing you know, they see, oh, there's a chief restructuring officer. What does that mean? Like, should I tighten credit? Should I cut off credit? how can that potentially impact the business? Does anybody want to take that one?
Well, it's certainly a significant data point that any vendor or other creditor to a company shouldn't just ignore. It bears at a minimum some investigation analysis. Certainly not every company that hires a CRO is going to end up in bankruptcy, but it's a leading indicator. I mean, that's just reality.
Yeah, there may already have been some trouble stirring even prior to the CRO's appointment, right? So you may have already had some issues with key vendors, maybe on key contracts. I mean, the business is already sending a lot of signals. And one reason for getting the CRO in is because you're already getting squeezed, right? Suppliers are tightening. You might get a, cash in advance sort of issue. Liquidity is diminishing. So it can be a very positive sign to your key constituents, and not just your lender, but also your other key constituents, that you're paying attention to the issues. You have the resources, you're turning things around, and it's very supportive. And that can help. So it's maybe a good point to talk about a PR strategy, right? So as you're going through a distressed situation, if you are a company that has a very public presence and you want to maintain confidence in the markets, you might even consider a PR professional to assist with communications.
So the other thing is CRO, the chief restructuring officer, the same human being, the same professional services firm might be appointed CRO of a financially distressed company, or it may simply be hired as a financial advisor to the same financially distressed company. And all else being equal, if a CRO is appointed, in my experience and in my opinion, that is, like I said, it's a leading indicator, because a company that has the option to hire somebody as an advisor, as opposed to, and CRO is not a self-defining term. It's kind of like the term of counsel at a law firm. Everybody knows what a partner is, for the most part, an associate, but the title of counsel, unless you look at the of counsel written agreement, you don't really know what that relationship is. And so, does the CRO have authority? Does he report into the CEO, or can he make, CEO-like decisions? Does he report directly to the board? There's a lot of detail in there, but all else being equal, the appointment of a CRO is not a good thing from the perspective of creditors. There's also a big distinction between, Candace mentioned, if it's a public facing, a company that has has a lot of notoriety. That's not that's a different question than the question of whether the company is private or public. Almost needless to say, a private company has more optionality to keep information private and close to the vest. And in terms of communications, usually, in my experience, it's kind of like, who at the company knows that restructuring advisors, restructuring attorneys have been retained. It's usually on a need to know basis, and it's limited as possible to, up to a point in time, very senior executives. I've been involved in more situations than I can remember, where we went into the company, 3, 4, 5 of us for debtors counsel went into, physically went to a company, and we certainly wouldn't bring briefcases, the soft cases that sometimes have a firm name on them. You wouldn't bring that. And we were going under a cover story. We weren't there as, restructuring advisors. And sometimes for even very large companies where it would have been a hell of a lot more appropriate and efficient to have 10, 15 people at the company helping get the company ready for filing. You have maybe 2 or 3 that are really under the tent. And if they're asking their subordinates for information to help plan the turnaround, which may or may not turn into a bankruptcy, they often ask for information to their subordinates without saying why or making up some
For the
other
auditors.
story. Say
For the
again?
auditors.
Right, for the auditors, right.
No, but I want to pick up on one thing that Ken just did say, and this is something that I as my career has gone on, I really do encourage is that if you're a company that has the financial resources to do this, and especially if you are a really public facing company, or one with a lot to gain or a lot to lose, hiring an expert communications firm that has done this before is great, because I can't tell you the difference that it makes for what Jonathan just described. Some people that may not have been under the tent until the filing literally happens, and they're getting a million phone calls, and having someone you can hand them and be like, here's all the information you need. It's all packaged in there. And look, every situation is different. There's a lot of similarities, but having folks that know the process, know what's going to happen, whether it's in court or out of court, and that can help message whatever the situation might be, it really is critically important, because Jonathan's right. You see the word chief restructuring officer, a credit manager is going to look at that and be like, I'm tightening terms. That's going to be their gut reaction 9 times out of 10.
So John, a lot of what drives a business to choose a particular strategic alternative is the liabilities that the business is looking to restructure, right? So can you give us an example or two of important considerations and how those factors impact the various alternatives that a company might consider? A Chapter 11 restructuring, an out-of-court restructuring or workout, an assignment for the benefit of creditors, et cetera. And are there any drivers that are more pronounced and maybe in today's recessionary environment than there were, say 5 years ago when the economy was blowing and going?
Sure. I'll answer your question by using some examples. So let's say you have a company that, without regard to debt service, is cash flowing and would be all right, but the debt service is crushing. And the debt service I'm talking about in this particular example would be senior debt secured by substantially all of the assets of the company. If that debt is particularly if the debt is undersecured, meaning if the company were sold in a short period of time, there would be the proceeds would be insufficient to pay off the senior secured lender in full. That's a good, simple fact pattern that would allow, assuming the senior secured debt holder, the senior creditor is open to it, that would allow a friendly foreclosure process, meaning the lender can foreclose under Article 9 of the UCC, sell the owners or some of the owners of the distressed company can buy the assets from the bank, and it's a different pathway to the same good place that any restructure, from the perspective of the company and its owners, that from their perspective, that any successful restructuring would offer. They end up on the other side owning the assets of the company, and if done properly, and if the assets, including that the assets were marketed properly, commercially reasonably, if everything is done in a kosher way, they could end up on the other side owning the assets of the company as a going concern, and they may have paid less than the face amount of the debt, of the senior secured debt. They'll have wiped away with some caveats that I won't get into unless you make me, with free and clear of unsecured claims and also free and clear of any junior liens. So that's like one example. A second example, actually a counter example, sort of. This process of a friendly Article 9 or friendly foreclosure is totally unavailable to a company that doesn't have debt secured by substantially all its assets. The very reason the first example was doable in the way I described is because if the short logic is if the senior secured creditor is owed, say, $10 million and they accept a bid of $5 million, then generally speaking, unsecured creditors can have nothing to complain about, because if it had sold for 6 million or 7 million or 8 million, the undersecured secured creditor still would have been paid all of the proceeds. So that's why that works. But if you don't have a senior secured creditor, then the so-called friendly Article 9 or friendly foreclosure, it ain't a thing. In which case you might use an assignment for the benefit of creditors, which is another pathway. It's not available in every state. It's available in some states. It's another pathway that sets up a process that, if done properly, not under the dark of night, but everything has to be, the assets of the company have to be exposed to the market so someone else can come in and bid. But if all of that is done, and then same thing, the owners of the old co can essentially buy back the company from the assignee in the ABC, the assignment for the benefit of creditors. What else? You asked earlier about mass tort.
Yeah.
And I guess one thing I can add to that in the context of this question is that if the driving force towards the bankruptcy involves alleged liabilities that involve, mass tort, product liability, environmental, retiree claims, a certain species of claims. I buy widgets from you, I owe you $20. That's a general unsecured creditor. It's not special. That's the kind of the general unsecured debt that has the lowest priority in bankruptcy, and and can be discharged. It can be avoided. You don't need a bankruptcy. Bankruptcy is like, what's the expression? You don't need to hire Michelangelo to paint your garage. Bankruptcy is more expensive. It's more time consuming. It requires a lot more resources. So if you can avoid it, you should. But there are some types of claims that, unless you use the bankruptcy, you can't really, any buyer of the business, whether it's you, the owner, you being the owner, or some third party, they won't take title free and clear with the same level of certainty and degree that they would through a bankruptcy process. I'll shut up. That's a lot of
No,
talk.
that's very insightful, and that's exactly right. And do any of you guys have thoughts on what types of drivers you're seeing today in terms of today's market, right? Like, what are some of the big liabilities that are driving companies into bankruptcy in 2024? Which, by the way, is the highest number of bankruptcies, large Chapter 11 cases since 2011. So we're coming out of the great financial crisis, right, from 2008, 2009 time period. So still a lot of companies filing at that point. We're now back to those type of levels of big Chapter 11s being filed.
Well, I'll just add a group of, I'll say these are industry verticals that are experiencing some structural distress, and that's healthcare and anything that was a net loser through COVID, right? So restaurants, hospitality, leisure, event planning businesses, services that are, you know, really very discretionary. So as consumers have, I think, responded to the high inflation, you know, there's been a lot of retrenchment, but also not everything has really bounced back from COVID. And sometimes, you know, businesses have made, you know, poor decisions, we'll just say. And that includes a lot of debt, a lot of high interest debt, and just couldn't operationally pull it off. Healthcare has a large number of problems. You know, I think that we should probably look at how we fund senior care, senior living, CCRCs, all of those investments probably need another look, because now I'm starting to feel like, you know, anything that survives off of government subsidies and poor wages for nursing staff is probably a bad business, and has a great deal of vulnerability. I've just seen a good number of healthcare cases. The MCAs, so these are merchant cash advances. These are high interest. Think of them as kind of loan shark sort of loans for small business, mid-sized business. They're sometimes documented as an accounts receivable purchase deal, to try to avoid usury law. These things are deadly. I have had companies seek refuge in Chapter 11 because of them. You know, they will sue you if you stop paying, and usually they just take all the cash in the bank account. And they're hard to settle and get rid of, and they have personal guarantees. So one thing that I'm very concerned about as to how businesses were responding to the financial distress of COVID is that they just ran right into these bad lender situations, and they're hard to, you know, they're hard to defeat and extract yourself from them. Very dangerous. I would describe it as a lending weapon of mass destruction, and I'm seeing them everywhere.
Yeah, to kind of almost harken back to something that we were talking about earlier. I can't tell you how many times I've seen situations where well-meaning or otherwise principals or debtors start entering into these, we call them MCAs, but whatever it is, basically short-term gain, basically to throw, I mean, it's not even a Band-Aid, it's a piece of masking tape over a, you know, gaping flesh wound, and that actually makes their situation much worse and is only staving things off for maybe a month or two. And so when I said earlier, like, don't make it worse, that's one way you can make it worse. It is very, look, in this credit environment, although interest rates may be falling, you know, so in COVID times, we didn't see nearly as many. I think we were all really prepared for the bottom to fall out, and for all of us restructuring lawyers to be so busy we would never see our families. And that didn't happen, largely because, I think for good reason, the government bailed people out. You know, there were a lot of, in those industries that were hardest affected, there were opportunities for that the government gave to people where they wouldn't immediately have to file for bankruptcy. Now, as Candace said, you know, some of this is coming to roost. Some of these financing deals that people kind of just plugged away for a little while, and the lending environment is such that you're not going to get favorable terms right now, and so you're not going to be able to refi your debt. And what's going to happen? You're going to have to work on some sort of restructuring, and so just I definitely see it in healthcare, some real estate. You're definitely seeing out businesses that are, you know, real estate heavy. There's a lot of even international insolvencies in the real estate markets, but it's almost like it's almost industry agnostic what I'm seeing right now. A lot of it is just, if you're kind of in the same situation where you're just distressed, and frankly, you see it in most markets, they're going to start filing.
Yeah. So Candace, I want to go to you. You know, we've talked a little bit about operational challenges and some of the liabilities that we see Yeah, I look at restructurings a couple of different ways. There's usually a balance sheet restructuring, companies that are just overweighted with debt and can't pay all that debt back. And then there's really the operational bankruptcies where there's something fundamentally wrong in the business that needs to be fixed. And you can't do it unless you go through a bankruptcy process, i.e. a massive fraud, right? Like you got to figure out what's going on. My question to you, Candace, is, what type of strategic alternatives are available to companies facing significant balance sheet challenges, and what are the pros and cons of those various approaches? And I'm going to go to slide 10 and 11 here.
Yeah, Jonathan raised introductory comments on several of these options, but I'll just draw a broad spectrum. Strategic alternatives can occur both out of court, private negotiation, often with the principal lender, all the way through to a court process, Chapter 11 being highlighted here. The assignment for the benefit of creditors, that's an out-of-court process in most places. Some jurisdictions will require some really basic filings, but not much, not a very heavy process, not like bankruptcy. But you basically put control of that assignment in an assignee. So one thing that is a little bit different, right, is that Chapter 11, usually the debtor can continue to remain in control of the business through the restructuring process. That has a lot of benefits, including how the directors and officers are treated to the extent that they can get those releases for their conduct. In an ABC, you don't get those protections as the debtor and the management team. The assignment can often look very similar to a Chapter 7 liquidation process, but it's happening out of court. Well, what does that mean? You don't have the benefit of an automatic stay. Right. So, it's still a negotiated solution. It often relates to some kind of sale or liquidation process, might just be a change of control transaction, but it will be run by somebody, not the debtor's principal. A workout private deal, you're just working out, right? So maybe your only problem is your senior lender. Well, then you focus on the senior lender and you work it out. And if it's more than that, if it has litigation, then you shift back down the spectrum to a Chapter 11 because you need the benefit of the automatic stay and the ability to coerce all of those parties, right? It's a collective proceeding. Coerce them into your courtroom, right? And if you're the debtor, you have a lot of leeway to run that process because you want your plan to be confirmed, right? How you're restructuring the balance sheet, and you want to use the tools that are available to you in bankruptcy. But I would say, by and large, typically what I'm seeing for distressed businesses is some flavor of a sale. And you're either doing it out of court, can be a private sale of substantially all of the assets. You're drafting up an asset purchase agreement. And, the company may have so few liabilities that the buyer's fine with that. It might be a UCC process if, right, as Jonathan said, this is under Article 9, you can qualify for it. And it's appropriate for the circumstances. And then Chapter 11s are trying to go very quickly, and they usually go quickly through a sale process. And under Chapter 11, that's Section 363, and the sale may already be fully teed up before the debtor even files. And I've been seeing some very, very quick cases, Delaware, Houston, doesn't matter, very quick cases because the sale is pretty much teed up and they're ready to go. And you tell the court and all the creditors and the creditors committee that gets appointed in the case that, hey, we have to do this sale imminently, or, the assets are going to decline in value and our ability to, capture and preserve value for the benefit of creditors would be vastly diminished. So we need to have this accelerated process. And that seems to be getting through almost all the time. It's pretty hard to stall out a sale process, either under a UCC out of court or under a Chapter 11. But that's usually what happens, is that the distressed business is facing some kind of change of control transaction.
Awesome. Steve, Candace was talking about the balance sheet restructurings. What about operational challenges? What are some of the alternatives that businesses might consider in that circumstance, right? You've got fraud, or you've got some other operational challenge in the business, like you've sold way too much free shrimp to people. Like how do you otherwise deal with that?
I can't imagine you're referencing any specific case that sold way too many free shrimp to people. Although that was one of the most interesting first day declarations I ever read. I was looking forward to that. Well, it's a good question, and it was one that I was noodling on for a little bit, because in thinking about this panel, if you're in a situation where let's say your operational challenge is fraud, I honestly truly don't really think that you have much of an option but to file for bankruptcy, and the reason being that fraud is also criminal. Fraud can be criminal, and usually if there's already kind of fraud that's been unearthed and discovered, it's always the tip of the iceberg. I've seen enough of these, or whether it's actual fraud or just not great business practices that are kind of bordering towards fraud. There's frankly not a lot you can do out of court that will protect the business and its viability. I think unless it's kind of very light or you have everybody on sides. Usually when I hear fraud, it's not a good thing. And frankly, lots of businesses that their operational issue is fraud, it's being held together by toothpicks and gum. So there's not frequently a big business that's underneath it. Maybe there's assets. Certainly somebody like Bernie Madoff, there were assets there for sure, but there wasn't a business. There wasn't something that was a viable operational thing behind it. So sometimes what you have to do is sell things off for parts and go out and pursue what you can from the fraud.
I think that's very narrow-minded. I mean, they could have just kept Ponziing.
That's right. They could have kept Ponziing, but you know what? That's when the criminal liability that I just mentioned gets a little bit worse over time. But no, I mean, look, you're right. I mean, that's kind of the alternative is keep doing the fraud, or restructure in a supervised proceeding. Because honestly, look, no matter who you are, if someone were to come out there and say there has been fraud at this company, but don't worry, we got this one handled. We don't need any oversight whatsoever. 0% of counterparties will believe you. It will never happen. One of the great things about a Chapter 11 process is it is supervised. There's a lot of transparency, and it gives people confidence in what is happening is a good thing. But look, let's put fraud to the side. There are plenty of other operational problems that are out there, and that could be out there. And if your issue is an operational problem with, I think it really runs the gamut. If your operational issue is something that is with one contract counterparty, for instance, like really the operations have been negatively affected by one counterparty, contractual or otherwise, you could try and restructure that relationship just like you could if they were a secured creditor, right? I mean, if it's just one party and Candace and I get in the room, we sit there and talk, we can have a conversation. But if you put 500 people in the room, that's not going to happen. You can't do that. So it's definitely a sliding scale of what's the operational issue. If your operational issue is the CEO of your company doesn't know how to run a company, okay, maybe you put in a new CEO and things can run a little bit better. But sometimes I've certainly seen companies where the culture of the company is such that you can replace from the top, but everything below is just kind of so infected by bad operations. It may be a good company in concept, but it needs to be run by somebody else, and they need to decide which employees they're taking, which employees they're not taking. So you got to sell it. So I do think that if your problems are more operational in nature, and you're at the point where you're in financial distress and you have operational problems, I think it's a lot harder to avoid a Chapter 11 because, as I've said about one client before, that things went south. You can fix operations, right? You can do that. You can fix bad management. Okay, you can do that. You can fix a balance sheet, but you can't do all three at the same time and then expect to be solvent really quickly. It's not going to happen. And at a certain point, your lenders aren't going to go ahead and just start throwing more money at you and be like, yeah, no, we'll give you a few more years to fix all three. At a certain point, you're kind of going to be hamstrung by what dollars you have in the bank, and you're probably going to go into Chapter 11 anyway. At least that's my experience.
So, John, just picking up on that, you know, one issue that I've often heard people talk about is the size of the business, right? In terms of the way that you can restructure, and you know, the footprint of that troubled business. Like a big company may have more options than a small company. So, do you think that's truly the case, or do you think that the same issues cut across all different sizes of businesses, such that size doesn't really matter?
Size matters. Most of the legal issues that exist for a small company exist for a large company, million, 10 million, 100 million, billion. We can use whatever metric we want of revenue, of debt, of whatever metric you want. The legal issues tend to be the same. All else being equal, I suppose, even where we sit now in 2024, the likelihood that a very small company has a union is less than a very large company having a union, I suppose, although I'm not even sure that that's true. What I'm trying to do right now is think of an example of like, where might a legal issue only exist at one spectrum of size versus another. But I don't think that's even a good example. Lots of small companies are unionized.
What about small business loans, right? Like small business administration loans versus, you know, a large company is not eligible for those type of loans, right?
Sure. So the players are different, but the legal issues are the same, right? Practically speaking, though, when more money is at issue, more money can and should be spent fighting over those things at issue, right? One can think, you could think of this simply as sort of an example of economies of scale in action. If I'm fighting you over whether, we have a legal dispute over X, and either the answer is this or it's this. I'm using my hands to indicate A or B. And if the result of it being A versus B is that one of us is going to pay the other $100,000 versus one of us is going to pay the other $10 million, we're both going to treat the entirety of the dispute very differently, even though the legal issue may be exactly the same.
So John, like, are there different tools that you might have? Are there different pathways that you might have as a small business versus a large business, right? Like the bankruptcy code, you have different tools, right, under the bankruptcy code. So can you talk just a little bit about that?
Yeah. Well, before I forget though, I wanted to go back and mention one thing about you asked Steve the last question, and what was it? Strategic alternatives for operational challenges. The one thing I don't think anyone has mentioned on this webinar yet is, and there's a reason for that. The title of the webinar is, what is it? Dude, where's my car?
Dude, where's my car? Right.
Yeah, it's my business is in trouble. So we're inherently talking about distress from the perspective of the troubled company, parentheses, AKA the debtor. But from the perspective of creditors, and I'm going to get to my point in a second, if the debtor doesn't figure out how to file Chapter 11 itself first, in situations involving fraud, the company very well may find itself in receivership, whether it's a state court receivership or a federal equity receivership. Those tools, they're not debtor tools, they're creditor tools. Those tools have increased in use, not exponentially, it's probably an exaggeration, but tremendously over the last 5 or 10 years.
Well, and to add on to that too, right? At least in my experience over the course of the last year or so, there's more creditors using involuntary bankruptcies than there have been maybe over the last 5 to 10 years, right? Like I've seen more an increased use of that as a tool to try to force a debtor to deal with its problems and address, you know, credit that it's owed to, various constituents.
I have not, so this is very anecdotal, right? It's not like my experience is my experience. I'm hardwired to advise, generally speaking, my knee jerk is to advise against an involuntary if I'm representing creditors. I see more downside than upside, and often, but not always, if you can, if the situation exists that an involuntary is appropriate, that same situation is more not unlikely to be susceptible to a receivership action.
Yeah.
But
Fair
it's a
point.
debatable point, and
Yeah.
maybe it is up. Your pending question though was what? You talked about like which
Small businesses, right? So small businesses versus a large company, right? Like what tools does a small business have available to it versus a large business, right? Like so you've got
Sure.
subchapter 5 of the bankruptcy of subchapter 5 of chapter 11 of the bankruptcy code being a simple example, but are there others? Maybe
Yeah, I
talk a
mean,
little bit about those.
yeah, if we're playing Family Feud and, we asked 100 restructuring lawyers, yeah, subchapter 5, probably would be the most popular answer, or an ABC.
Mhm.
And subchapter 5 is awesome, from the perspective of the debtor. As everybody who practices and involved in corporate restructuring knows, the debt limit was lowered from 7.5 million to 2 point whatever million, which is a limiting factor. But if you can make your company fit into subchapter 5, it's a no-brainer. I don't need to know the facts of the situation to say that it's probably a no-brainer. That's where you want to be. And of course, early on, the following was an interesting and maybe intelligent point. But at this point, I think everybody knows it, that the 2 point whatever million dollar limit, where if you only qualify if your company owes less than, does anyone know the exact number?
Yeah, it's a little over 3 million.
3 million.
That's adjusted.
Okay, so a little over 3 million, but of course, and here comes the punchline, that's the only debt that's counted is liquidated and non-contingent debt. So even today, if we're dealing with a company that has $100 million of debt, that's not enough information to know that subchapter 5 doesn't work. That's not nearly enough information to know that it doesn't work. It depends on if the debt is legitimately contingent or unliquidated. So that's a thing. And then the assignment for the benefit of creditors is traditionally better. The bigger you are as a company, the more spread out your operations are geographically, the harder it is to do an assignment for the benefit of creditors that really gets you what you need, because you get into issues of cross jurisdictional issues, because an ABC by definition is state law, and you commence an ABC in Illinois, but there's assets in Michigan. Do you have jurisdiction over the Michigan assets? All sorts of questions arise, which actually are pretty navigable in practice if you're dealing with 2 or 3 states. But you're dealing with a lot of states, then it becomes harder. And in case anyone doesn't know, the Uniform Commission is in the midst of a 1-year project to write a model law for assignments for the benefit of creditors. I'm an observer to that. And that's an interesting development. Anyway.
One of the other things I'd throw out there, having to do with small businesses, smaller businesses, is when you're talking about, I think Thad, you said it, that it's a lot of the time we're going down the sale path. I mean, that's frequently what we're seeing in restructuring cases and bankruptcy cases. A sale is much easier out of court if you're smaller. If for no other reason, then look, you can't get a free and clear. It's going to be, it's either going to be two things. It's either going to be not free and clear, or only free and clear if a counterparty to that debt agrees it's free and clear of my debt. So either way, it's easier to negotiate. Or maybe if you only have, I don't know, 20 creditors, 25 creditors, a counterparty can probably get a purchaser counterparty can probably get more comfortable with the amount of debt that you have if you're smaller than if you're larger. Otherwise, in all likelihood, what they're going to say, because they know the bankruptcy code exists and they don't have to pay for it, is that they're going to say, no, we'll only buy under 363, the bankruptcy code. I mean, and similarly, and this doesn't really necessarily have to do with the size of the business, but like contracts usually have clauses that say you can't assign this. In bankruptcy, you can assign contracts, even if there's something that's in there that says you can't assign them. But again, if you're a smaller business and you have one contract that needs to be assigned as part of a sale, it's a lot easier to call up ABC Corp, your counterparty, and say, hey, this cool, can we do this? Rather than 500 contracts that you couldn't do that. So I do think that the size of the business will kind of dictate what the most likely outcome is, but I've seen larger companies have out of court sales. It depends on where the sale counterparty will get comfortable.
Staying on out of court for a minute, but getting away from the sale and going back to the restructuring concept. It's hard. It's impossible to sort of track numbers. Everybody knows, if they want to look it up, exactly how many bankruptcies were commenced Chapter 11 in whatever year, whatever quarter. There's no good way to track the number of out-of-court restructurings, aka good old-fashioned composition agreements. But I've done, I've been lead debtor counsel to, I don't know, 4 dozen companies, I suppose, in my career. And then, worked as a junior person on a lot more cases, but I've done far more out of court workouts than that. And a standard sort of dance move or tactic is, and this is also, if you're part of a close-knit industry, the schmata industry in New York City is a great example. The furniture industry has always been a great example, where all the players know each other, all else being equal, leaving size aside, all else being equal, if it's a close-knit industry, you can often get something done. And the sort of the dance move I like is if the debtor is struggling and can find sort of a white knight, not to buy the company, but to infuse some capital for either, whether it's a loan or whether it's a slice of equity or whether it's both. But you go out, the debtor goes out to the creditors, and again, it's got to be a manageable number. And basically it's, look, we have this potential white knight who's willing to infuse this money, which will go directly to your pockets, or at least a good percent of it will go directly to your pockets, if you agree to the following. And the following might be, take, instead of 100 cents on the dollar, let us pay you back 75 cents on the dollar, and let us do it over 3 years with 3% interest, whatever the numbers are. And this white knight is only going to do this if 90% of you say yes. And then you do a completely out of court plan, lowercase plan that has some similarity, some resemblance to a Chapter 11 plan, but limited. And that's that works. That works often, in my experience.
Yeah, my last question to you guys is that, one of the things that I'm seeing right now are companies facing significant debt maturities, right? And they're coming up against the maturity wall, so to speak. So, one of the things that we've talked about today are secured lenders and the import of secured lenders in this whole discussion. So how are secured lenders really approaching distressed credit situations, given the current economic conditions, given high interest rates, maybe not a lot of relief on that front coming forward, high regulatory environment for the banks in particular? So anybody have any observations on that front that you want to share?
Well, I'll share recently doing amending, extending, still forbearing, maybe with some sweeteners, right? So as you suggested, interest rates might go up, fees, costs, etc. So if the company is able to operate, you can push it down. Because one thing you want to try to do for a lot of lenders, especially if they're non-traditional lenders and they're in an industry where it would be very painful to take a loss on one of your loan investments, is that you're looking for an opportunity to be taken out at par. So that has occurred successfully. I think that the rise of private debt is certainly very helpful to create some new exit opportunities for lenders. And so my work recently has been around preserving those options for a better exit, in the future.
Anyone else have something to share on that point?
I don't think we have enough time.
All right. Well, look, thank you, panelists today. Steve, Candace, John, great work, great job. We hope everyone else had fun today with us. Slides 3 and 38 both remind you that you cannot go out and make important decisions based on what you heard or learned here today, if anything. We want to make clear that we are not your advisors. You're not our clients. This presentation really was meant to give you a general knowledge to help you select and work with advisors going forward. So this concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thank you.
Thanks,
Thank
Matt.
you.
Great, thank you.